Hi, my name's David Haig. I was tased 10 times in Anchorage Court on December 18th for trying to present evidence that the Alaska Court of Appeals is fraudulently eliminating evidentiary hearings that would prove serious corruption within Alaska's judicial system. Since I was unjustly prevented from presenting my evidence in court, I'll present it here. This is the Court of Appeals for the State of Alaska Memorandum Opinion number 6416, December 21st, 2016. In this memorandum opinion, to eliminate an evidentiary hearing on one item, the Court of Appeals states about Attorney Robinson's failure to call Attorney Cole as a witness at my sentencing. They state, at sentencing, Haig wanted Robinson to call his former attorney Cole as a witness to testify about what Haig considered to be the state's breach of a prior plea agreement. Haig also wanted Cole to testify that the state had previously agreed to give Haig credit for the year that he had voluntarily refrained from guiding during the plea negotiations. Despite Haig's request, Robinson did not call Cole as a witness. The district court rejected this claim for failure to state a prima facie case of an ineffectiveness, concluding that Robinson's decision not to call Cole for the sentencing hearing was clearly a tactical decision, and that Haig had failed to offer a prima facie case that Robinson's decision was unreasonable under the circumstances. The district court noted that at the time of sentencing, Haig and Cole were immersed in a contentious fee arbitration case that had not resolved. Given this record, we agree with the district court that Haig has failed to offer a prima facie case that Robinson acted incompetently when he made the tactical decision not to call Cole as a witness at sentencing. This is the judgment against me, the final document in my sentencing. State of Alaska versus David Haig, judgment. It was made on September 30th, 2005. It was signed by Judge Margaret Murphy. September 30th, 2005. That's when the end of my sentencing occurred. Here's when I filed for fee arbitration against Brent Cole. David Haig versus Brent Cole, petition for fee arbitration, for arbitration of fee dispute. It was filed on February 10th, 2006. In other words, I filed for fee arbitration 5 months after I was sentenced, proving I was not, at the time of sentencing, immersed in contentious fee arbitration case that had not resolved with Brent Cole. This is the law concerning plea agreements. There's a bunch of them, but I'll just go over two. The government must adhere strictly to the terms of agreements made with defendants, including plea, cooperation, and immunity agreements. Santabello versus New York, 404 U.S. 257, U.S. Supreme Court, 1971. Where an accused relies on a promise to perform an action that benefits the state, this individual will not be able to rescind his or her actions. In the plea bargaining arena, the United States Supreme Court has held that states should be held in strict compliance with their promises. Courts consider the defendant's detrimental reliance as the gravamen of whether it would be unfair to allow the prosecution to withdraw from a plea agreement. Clausen versus State, 812 P.2D 966, Alaska, 1991. And I guess you can go back over there. Yeah. paid for with the guide year already given up for a plea agreement Attorney Cole and Attorney Robinson said couldn't be enforced against Assistant Attorney General Scott Leaders. I had paid for charges far less severe than what I went to trial on. This meant my trial conviction was invalid. Assistant Attorney General Scott Leaders had committed prosecutorial misconduct, and Attorneys Cole and Robinson were guilty of ineffective assistance of counsel and malpractice. This is why the Court of Appeals and the District Court had to lie that Cole and I were immersed in a contentious fee arbitration case that had yet to be resolved. To give a reason to deny an evidentiary hearing that would not only prove my conviction was invalid, but would also prove the collusion and corruption of my own attorneys with Assistant Attorney General Scott Leaders, especially since Attorney Cole failed to show up to my sentencing as subpoenaed. Attorney Robinson stated there was no way to enforce Cole's subpoena. Assistant Attorney General Scott Leaders and Trooper Gibbons testified at my sentencing they had no idea why I gave up guiding for a year before I was sentenced. There are tape recordings of Attorney Cole stating Assistant Attorney General Scott Leaders agreed to give me credit for the guide year if I gave it up before I was sentenced. There are tape recordings of Attorney Cole stating Assistant Attorney General Leaders broke my plea agreement to also get the airplane, and tape recordings of Attorney Cole stating he could not enforce the plea agreement he had made with Assistant Attorney General Scott Leaders because he couldn't do anything that would piss Leaders off, because he still had to be able to make deals with him after my case was over. Thank you for your time.